I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Alexis Geier versus American Honda Motor Company. This is a 2000 U.S. Supreme Court case about federal regulatory preemption of state law. And I have to say for my students, I'm making a companion video to go with this that's just a quick and dirty explainer about preemption, express preemption, implied preemption, partial preemption, and savings clauses that will be very helpful in untangling and figuring out what's going on in this case. The other thing about this case is when you read the facts, it starts out as a pretty straightforward car accident case when somebody was injured in a car accident, and it was a late 80s model Honda, and they said that if their car had had airbags, they wouldn't have sustained such serious injuries. So that sounds fine, like it's a car accident case, but the opinion itself is all about abstract legal doctrines of express preemption clauses, explaining it away, precedent saying that it doesn't apply, using a savings clause to offset the preemption clause, and then deciding that the statute preempts anyways. And so let's look at what happens. This is a hard case. Don't get discouraged if you are confused. Also, note the unusual combination of justices in the majority and dissent. Preemption cases don't split on party lines. And I'll explain this a little bit in the companion video, but this is not a clear conservative versus liberal issue. And so we usually have split opinions, like 5-4 decisions in the preemption cases, but it's not along the typical party lines that you would see in a 5-4 split or 6-3 split. So let's look at what happens in the Geier case. Some professors and case books may call this the American Honda case. In this case, the Supreme Court held that even though the savings clause made express preemption inapplicable here, allowing a state action would conflict with the federal phase-in requirement for airbags. And because of this finding, the court held that the statute impliedly preempted a state cause of action. And before I keep going, I just want to, here's our little preview or a flash forward about preemption. What's happening here is that car companies, when they're sued for because people get injured in car accidents, were using as a defense that they had complied with this big body of federal safety specs. So there's a couple federal agencies that put out safety specs that the car companies have to comply with in order to sell a car that's going to be driven on the roads in the United States. And so what they were saying was, if we're already completely complying and fulfilling the safety specs set by the federal government, then a state court shouldn't be able to hold us liable in tort law, because that's de facto or in practice expecting us to go above and beyond what we were already doing and make our cars even safer. And so what they're saying is, if you hold us liable in tort under any type of negligent theory, what you're basically doing is saying that we have to make our cars safer than the federal safety specs require of us. And that's how we got here in this case, is that Honda and other car companies were arguing that their compliance with federal regulations should preempt state tort cases in personal injury law. So Geier was injured in a car accident, and she brought a tort action for defective design against Honda, the car manufacturer, under DC tort law, or District of Columbia. The claim alleged that Honda was negligent in not equipping its 1987 cars with a driver's side airbag. And if you have watched my video about State Farm or read the State Farm um, versus Motor Vehicle Manufacturers Association case, you know that there was a lot of litigation and a lot of regulatory back and forth about requiring airbags leading up to this. Note that the driver in this case actually was wearing a standard seatbelt, but was still badly injured. Now, the court, and Justice Breyer wrote the majority opinion, which matters. Each of the justices, at least at this time in the late 90s and early 2000s, had sort of their own quirky views of preemption. So Justice Breyer here, who likes the experts at the federal agencies, is writing our majority opinion, and he says the court, first of all, he says the action is not preempted. Even though there's an express preemption provision in the relevant statute, the National Traffic and Motor Vehicle Safety Act. At the same time, he says that the Act's savings clause does not foreclose or limit the operation of ordinary, like common law, preemption principles. I actually think this little stone carving from the Yale Law School reminds me of Justice Breyer. So I actually want to take a minute to just have my students look at the preemption clause and the savings clause. This is a kind of an important area and definitely a cutting edge area of administrative law or regulatory law. So let's go ahead and look at how these look. Whenever a federal motor vehicle safety standard established under this subchapter is in effect, no state or political subdivision of a state shall have any authority, either to establish or to continue in effect with respect to any motor vehicle or item of motor vehicle equipment, any safety standard applicable to the same aspect of performance of such vehicle or item of equipment, which is not identical to the federal standard. And so I want you to notice what's going on here. This federal Congress is doing this, not the agency, although we do have some cases where the agency has tried to have this same type of preemptive effect. And what Congress is doing is saying, we want to have uniform nationwide standards. And this makes sense, a lot of sense for things like cars that are going to be driven across state lines. So you don't want to buy a car in New Jersey and find out that when you cross over into New York or Pennsylvania, that your car is illegal to have on the road because it didn't meet your state safety specs. And this is also a bit of a political compromise with the automobile manufacturers, right? They don't want to when we're passing this safety act that's going to require them to put safety features in cars. The sort of concession to the auto industry is that they'll only have to comply with one set of standards. They won't have to have 50 different, make 50 completely different cars for every state where they sell cars. But notice the strong language here, right? And they're justifying this under the supremacy clause of the Constitution, that if we have a federal car safety standard that is promulgated by the agency, so this doesn't actually create the standards. It says that the agency, the Department of Transportation and a subdivision of it, the NHTSA, is going to create the regs, then that basically cancels out or preempts anything that a state does. And we call this an express preemption clause. Now, the same statute has a savings clause. And we usually call it savings. Justice Breyer calls it saving clause, singular. Says that compliance with the federal safety standards, quote, does not exempt any person from any liability under common law. And so this is trying to save the common law of states so that a federal regulation doesn't just cancel out all of the common law tort law, let's say, in the law of negligence. So the court says, in other words, the saving clause assumes that there are some significant number of common law liability cases to save. And here's a quote. If you guys like highlighting quotes in your casebook, here I've pulled one out for you. A reading of the express preemption provision that excludes common law tort actions gives actual meaning to the saving clause's literal language, while leaving adequate room for state tort law to operate. For example, where federal law creates only a floor, that is a minimum safety standard. So this is the view that they're taking of savings clauses. And I hope you see that basically within one statute, the preemption clause and the savings clause are pulling in different directions. So before we go any further in this video, make sure you're clear on that. A preemption clause is going to say that this federal law and any regulations promulgated pursuant to this law are going to preempt or prevail over or cancel out any state law that's contradictory to it, that's not the same. Now, states can have laws that are identical to the federal law, but why bother, right? And then in the same statute, we have a savings clause that says that common law tort actions shouldn't be affected by this type of preemption. And I got to tell you, in a lot of cases, they have been. And some administrative law casebooks either have a number of cases for you to read or go on and on and on with note cases about preemption. And if you read through them, you are going to get confused because the cases are all over the place. All right. I'm not telling you not to read your casebook. I'm just saying that this is a confusing area of law because the justices can't decide what they think about this. So the majority ultimately held that the action was still preempted anyways. And even though they said that savings clause cancels out the preemption clause, they say that it is in fact conflicts with the Department of Transportation standards that required the car manufacturers to place driver's side airbags in some, but not all, 1987 automobiles. Okay, a couple closing points about this case. Note that the court does give some weight to the Department of Transportation's interpretation of this regulatory standards objectives, the airbag reg, and its conclusion that tort suits like this one would stand as an obstacle to the accomplishment and implementation of its regulatory objectives. And here's another quote for you that when they're talking about the agency's expertise, the Department of Transportation is likely to have a thorough understanding of its own regulation and its objectives, and is uniquely qualified to comprehend the likely impact of state requirements, nor do the agency's views as presented here lack coherence. And so where this leaves us is, and now we're not just talking about this case, but the preemption cases that are in the notes along with it, before and after it. Assertions of preemption are increasingly common. The big corporations that are the usual deep pocket defendants in personal injury lawsuits bring this up. They say, look, there's federal regulations that we're complying with, and those preempt state law, including any additional like negligence standards that a state court would apply. And so this comes up a lot in products liability litigation. The defense is not often successful, but sometimes it is perhaps a testament to the general presumption against finding that state common law is preempted by federal laws. In fact, Justice Stevens likes to say, we have a presumption against preemption, he says. Now, administrative law is a little different than constitutional law, so we don't obsess as much over the individual ideologies of each of the justices. But with preemption, it can be helpful to do so because it can help you think clearly about what's really at stake in these cases. For Justice Breyer, I'm going to oversimplify a little bit, and if he ever watched this video, he would feel like I'm being unfair and his views are much more nuanced than this. But Justice Breyer trusts the experts. He likes the experts that the agency hires. He thinks that the agencies get years and years of experience. They know what they're doing. They're able to specialize and focus. They do scientific studies and so forth. And he trusts them more than the elected state court judges that we have in almost half of our states around the country. And so if that's your view, if you are a little bit of a technocrat, then you're likely to kind of like preemption because you trust the experts at the agencies more than you trust somebody who ran for an elected judicial seat in a state election. On the other hand, you could have Justice Stevens, who at the time was still on the court and was part of the liberal bloc. But his type of liberalism was not Justice Breyer's technocratic view. It was more of the courts are here to look out for the little guy. And Justice Stevens often portrays things almost like every case is this David versus Goliath battle. And courts are there to try to even the score, level the playing field between the poor lone individual and the big bad corporation or the big bad government or something like that. And so if that's your view, if you are concerned about the common man and the citizen versus these all-powerful state or institutional or corporate forces, then you're not going to like preemption, right? Because preemption is always brought up by the big corporations and government agencies and stuff like that that want to cancel out the individual's ability to get redress under negligence, under state common law theories. Now, let's flip to the other side of the aisle. If you're conservative, but you're the type of conservative that's really focused on states' rights, you're going to hate preemption, right? Preemption is directly at odds with states' rights. So if you love states' rights, you really think of yourself as a federalist in the sense of not the federal government, but a federation of states and so forth, then preemption is going to kind of grate on you because we should trust the local rule and local state court judges and not have the experts in Washington making one size fits all rules for everybody in the country. On the other hand, if you are the type of conservative who thinks that we really need tort reform and personal injury lawsuits are out of control and are killing American business, and that individuals need to take more responsibility and not view every injury that happens as a way to get rich quick or have a windfall from the big corporation's insurance company, then you're going to like preemption, because preemption is a very clever way to cancel out a lot of our sort of state tort, common law tort claims, personal injury claims, by saying, look, we have a standard and the companies can plan ahead and can produce their products that comply with that regulation. And that's all they should be held with or held to. And part of this is whether you think that the federal regulations are a ceiling or a floor. Okay, enough about the quirky ideologies of the justices about preemption. We really are about done. See, there's my the end screen. That concludes my lecture about Alexis Geier versus American Honda Motor Company.